Okay, we are live on YouTube. Hello, Liz Fraley. How are you?
Hi, Judge. I am well. How are you?
Good.
Good. Thank you for joining us today. Class, let me introduce you to two of our prominent alumni, Judge Jennifer Edgeworth and Judge Tom Novak. Both are district judges in Collin County, which, if you're not familiar, first of all, go learn your counties. And second, it is a county north of Dallas. They graciously offered to spend their time with you this afternoon, talking to you about what they are seeing in the real world of Zoom hearings and what the future looks like for them, and then to share some wisdom with you about best practices that they are seeing. And so let me give you a brief introduction. Judge Jennifer Edgeworth is a 1999 Baylor Law graduate. While she was here, she participated frequently on moot and mock trial teams and was coached by the Sayers and by Professor Powell and did really well. So she proved her chops in law school before going out into civil practice for 19 years. She was a partner at two prominent law firms. And then in 2018, she ran for the district bench, was elected, and took the bench in Collin County in January 2019. I can tell you that during that time between when she was elected and when she took the bench, I was speaking at a couple of continuing legal education seminars, and Judge Edgeworth was at all of them. And she took it upon herself, because her court is a court of general jurisdiction, to learn the areas that she did not otherwise know, to buff up on criminal law. I think I saw her at the Hell on Heels family law seminar. But that tells you a great deal about the kind of judge she is, that it is important to her to get it right. And that certainly has borne out since she's been on the bench. She's uniformly been recognized as the best judge in Collin County, which is pretty terrific. And she kept that until Judge Tom Novak was appointed by Governor Abbott. He has a very interesting background. He actually was born in Poland and escaped as a refugee of communism to the United States in 1985. At the time, he didn't actually speak English and yet had to go to school in America, learn the language, and actually went ahead, attended Texas A&M, which, okay, we all have a few dings in our paint job. But he graduated and then came to Baylor Law, where he had a distinguished career. He met his wife, Judge Christine Novak, who is a federal magistrate judge in Sherman right now. So both their kids get overruled or sustained frequently at the dinner table. He brought a really unique skill set to the bench because he is board certified in criminal law. He is a captain in the Air Force Reserves, and then he also had a civil practice while he was out. Needless to say, these are two wonderful alums who know a great deal about trial practice, and they now are translating that into the virtual world. So once again, Judge Edgeworth, Judge Novak, thank you so much for your time, and I will turn it over to you.
Thank you. Well, we are thrilled to talk, air quotes, to our PC class. It's weird to think of, I was trying to think of what was I doing, when I was in practice court, and could never in a million years have imagined doing court remotely like we are now. It is so very different. And I will tell you, to all of the Baylor lawyers who are there because you love trials and you love the rules of evidence and being in the courtroom, it is soul crushing. And I get it. It has been really hard on the lawyers and the judges, but we're making it work. And we have to, because if we weren't coming up with something, then we wouldn't be able to keep justice going forward. So what we wanted to do was just kind of start off with a general overview of how did we get to this point with Zoom? Where did that come from? And what does that kind of look like for the district judges? And just also, for a little bit of background, there are 472 district courts in the state of Texas. Tom and I are unique in that we're general jurisdiction. So we do have all three areas. We have criminal, civil, and family. And I am very happy that I get to practice in the same courtroom with him now. He's upstairs, and I get to see him a lot. So that's been fun. And it really gives us a unique perspective because we've had to address Zoom hearings with all different kinds of areas of the law. So first question, how did we get here? And I would have taken you to the website. Unfortunately, it's down right now. But it's called the Office of Court Administration, and it's texcourts.gov. So txcourts.gov. And what is it? It is a state agency that is in the judicial branch, and it operates under the direction of the Texas Supreme Court. I am embarrassed, I guess, to admit I didn't know anything about the Office of Court Administration until I took the bench, and then really didn't know as much as I do now, because they have been incredible as far as kicking off how we were doing courts. They were on top of making sure that we could have Zoom hearings. By we, I mean all judges in the state of Texas, the second that the stay-at-home orders came out. And so what the Office of Court Administration did was obtain licenses for every single judge in Texas so that we could conduct Zoom hearings. And when their website is back up, I highly recommend that you just peruse it, because on the very first page, it gives you not only a list of all of the emergency orders, it has the actual order and then an explanation of it. For those of you that are starting to get used to Zoom, and especially if you're going to be conducting trials by Zoom with PC or in advocacy, there is a page from their website that gives you a whole lot of direction on what to look for, how to do it, how to practice it, which has been really helpful for judges and for lawyers that are having to do this. And if you have not already found this, there is a court YouTube channel directory linked to their website where you can go and look and click on any court that is having a hearing at that time in Texas. And it's all over the state of Texas. It's all kinds of courts. It is so cool. If you have an idea of where you think you want to practice, or you just want to see with how the judges are different or how they conduct court, I would be watching this all day long if I wasn't in class. So I highly recommend you peruse that when you have a chance, because in order to comply with open courts, and we'll talk a little bit more about that later, this was the solution by the Texas Supreme Court that when courts are in session, they will be streaming live to YouTube. The hearings are immediately deleted. They are not to be recorded, but it does give people the opportunity to watch. And so you may have also seen, or if you haven't already, I highly encourage you watch some Texas Supreme Court oral arguments. The US Supreme Court is having oral arguments. It's just a really unique opportunity to be able to see how courts are conducted all over the state of Texas. So we have been really thankful with the direction that we've been getting from the Office of Court Administration. And that is what initiated how we got to Zoom and how the judges are doing it now. So what I wanted to do was kind of highlight the different areas of law. As Liz mentioned, Judge Novak's background is primarily criminal. He came, not because he is a criminal, he's a very good guy. He was in a district attorney's office. He's been a criminal defense lawyer. He has as Liz mentioned, he is board certified in that. So he had brought to the bench a really great perspective on how to conduct our criminal hearings as well. And we've really been working as a group. All the district judges in our county, Collin County, I can only speak for ours, to try to make sure that we're making it as consistent as possible for all of the different courts and for the lawyers and litigants that are coming before us. So I wanted to start with kind of what does it look like right now if you have a criminal case and you are trying to get your case heard, and what does that mean for you? So I will turn it over to Judge Novak.
Thank you. Thank you. Very happy to be here. No, I really don't have an accent, but at least I did pretend for a couple of days that I did with Pal in PC to make him think that I couldn't speak English very well. So that was a little fun. But no, thanks for having us. Just to kind of piggyback on what Judge was saying, some of those things that you kind of learn later on, I didn't know about the Office of Court Administration until obviously I became a judge. And that only happened in October when I was appointed by the governor. So I didn't sign on for this. I didn't sign on for a global pandemic, kind of messing up my first few months on the court and learning as we kind of go along. I'm still happy to be here, but it's a little bit different than I anticipated. With that being said, I will also point out with regard to some of the Office of Court Administration type stuff, there's a lot that goes on at the Supreme Court that I didn't really know about. There's a lot of groups, there's a lot of committees, a lot of hearings. And since the Supreme Court is charged with basically telling us as judges what to do and how to do it, there's a lot of information that I really didn't know is out there. And so from an advocacy standpoint, I'll point out that if you find something on there, whether it's some committee letter or some kind of information that they're working on, and you bring it to court and tell me that the Office of Court Administration is doing this or suggesting we do it or getting those numbers from that group, I'm probably going to go ahead and agree with whatever it is you're saying, especially as a new judge who's trying to learn and figure some of this stuff out. It makes it very difficult to know everything right at the beginning. And I would say it's probably the most persuasive type of evidence or information you may have in court right now. I can sit there and look up the cases, but if you tell me something from court administration, it's probably going to make me do what you want me to do very quickly, just because I'd be afraid of making everybody on the Supreme Court or the Court of Criminal Appeals very angry. Having said that, we've got different policies and procedures for kind of civil cases, family cases, and of course criminal cases, which each of them have their own unique challenges and perspectives. And so we'll kind of start with the criminal stuff, since that's kind of where I made my name, as it were, before I became a judge. And it's been very difficult for us, obviously, because we're keeping people in jail. We're not trying to let people out merely because there is a pandemic. In many respects, some of the jails are cleaner and safer than some of the places these people would be otherwise. That the inverse is true as well. There are some some jails that are quite dirty and not the best place for people. So we've kind of had to balance those issues. With that, the Court of Administration, the Office of Court Administration have told us that we just can't let people out because of the threat of a pandemic. So we're still doing the things that we need to do to make sure that if we are letting somebody out, we're making sure that they can't be a danger to the community, that they aren't going to cause any more trouble while they're out there, or bother the victims of the crimes. All the things that we took into account are still being taken into account in determining whether somebody gets out of jail or not. Also, we're still having hearings. So some of these, you may have heard the terms, in terms of essential hearings or non-essential hearings. For the most part, everything is non-essential with a few exceptions. One of those would be, for criminal purposes, bond settings and making sure that people have a bond set, or if they're requesting to get out of jail, that we have that hearing. And so what that means is I could require them to show up in person, and we'd have to follow social distancing guidelines and put masks on and do those kinds of things to ensure that everybody would be safe in the courtroom. We're lucky in Collin County in that we have the technology to basically do all of this remotely. Our jail went ahead and bought a bunch of iPads so that defendants could communicate with their attorneys from their offices. So we have the ability right now for attorneys to just, basically sit in their PJs or at home or in their offices and call the defendants and talk to them about their cases, because we still want to move them. And if we do have hearings, we can do those remotely. A lot of times we don't need the defendants to be there. We can do it by submission basically filing all your paperwork with the court, emailing us, and having us make a decision with maybe some oral argument through Zoom or whatever other means we can come up with. There's different requests that have occurred throughout this process, and we've been very amenable to doing whatever it is we can to move these cases along. A lot of times the defense attorneys want to get paid on their cases. The defendants want to move along with what's happening on their case. They want to start their probation, or even in some sentences, start their sentence in jail or prison to kind of get that knocked out of the way. Now the jails aren't transferring, they're not transferring to prisons either, but we can book somebody in our jail and have them start their sentence. You might have seen in the news some issues with the governor getting sued at his order that prohibited defendants getting released on what we call 90-day writs. If you sit in jail per the Code of Criminal Procedure for 90 days and you haven't been indicted with any case, you're entitled to petition the court to get out on what's known as a PR bond, basically for free from the jail, because the state's not ready to proceed on your case. So the governor suspended that provision of the code. And there's some cases kind of trickling their way up at this point in time as to whether or not that was constitutional, as to whether or not the governor could suspend that provision. So you have these issues where somebody's sitting in jail, they've been charged with a crime, but they haven't been formally indicted with a felony case. So what do we do in those cases, and how do we deal with those have been the questions that have popped up while we've been going through this kind of crisis. And so these are very interesting questions. And I'll tell you that the way they're resolved here in Collin County is we still look at everybody individually. We go through, we'll have a bond hearing, and we'll let people make their cases for why they shouldn't be in jail or why they should have a lower bond. At the same time, our technology has allowed us to do pleas with defendants in jail or those defendants on bond. One of the things that we had to figure out is, okay, well, how do we get their fingerprint? If they're not here, what do we do? So we've had a situation where defendants voluntarily can come in to our court. Everybody else is remote, not there. And then they'll do the plea through an iPad in the courtroom or a laptop in the courtroom to, again, allow them to start probation, to allow them to start paying their debt to society. As for trials, we haven't quite gotten there yet. The Office of Court Administration is working on guidance. You'll see that come out. So I would encourage everybody who's kind of in the mix or about to be going out, working with these firms and working in PC as to how that's going to happen, is to look at that guidance and see what the Office of Court Administration recommends. We always post that information on our district court's Facebook page as well. So that's one more place to get information. And I know a number of courts obviously do that around the state of Texas. So the advice is great from Judge Edgeworth. Take a look at some of the other courts. I don't know that I would have been sitting, spending my time in PC watching other courts do that stuff. I didn't make the grades that Judge Edgeworth did in PC. I think it's a good way to at least get some trial skills and at least find out what that judge, what their temperament is like. And again, you'll be much better prepared than anybody else from another law school just by virtue of taking a look at what everybody else is doing, wherever it is that you may be going to work.
Yes, and it's definitely been a lot of collaboration with all of the different groups that have a stake in this. So we've been working with our sheriff's office, we've been working with our bailiffs, with our clerk's office. There's so many moving parts, and Judge Novak really took a big step with that, and it's really been helpful with helping us to get that to go forward as well. And it's interesting to see how different counties are handling it. So as we keep taking every step. And our grand juries are the one thing that is meeting in person. So that has been, in Collin, we have a gigantic central jury room. And so we have only been calling in the grand jury so that they can hear the cases, and that's what leads to your indictments. And that was one specific part that the Office of Court Administration and then the Texas Supreme Court pointed out, they can meet in person. We do know that the Texas Supreme Court is currently working on, how to figure out how are we going to have jury trials. We haven't heard that yet. We know it's coming and we appreciate the work that they're doing on it. In Collin right now in our county, we're set up to have one of the first remote summary jury trials, which is a procedure you can do in civil cases where you have a one-day trial and then the next day the judge presiding. So it's not going to be that particular judge of the court, but we call them visiting judges, to mediate the case the next day. And so our district clerk's office has sent out jury summons to those participating in a summary jury trial. It's in Judge Jill Willis's court, and they will not physically be coming in, but it will be really interesting to see how that works and how that looks. So moving on to the civil and family cases and how we are dealing with that. We have one court that is civil only that was just created this past session by our governor. And for our judge, Judge Andrea Baressa, she has really taken it on and tried to come up with her procedures on how she's moving forward. And she's been able to do a lot by written submission. So especially if you have a summary judgment hearing or a discovery motion hearing, she's been able to move those forward by just reading the pleadings and ruling. One thing that the Supreme Court did also that helped us was lessen some of the requirements for the official signed affidavit. Well, actually we already have a statutory where you can do it by declaration, so you don't have to have a notary on an affidavit. But there are ways that we have been able to try to get things into evidence. And if we do have a Zoom hearing on a civil case, for example, or bringing in witnesses, it's hard because, especially with authenticity objections, you have lawyers on the other side. How do I know this is the right text message? And how do I know that this document hasn't been altered? And at the end of the day, as we know, does it purport to be what it is? And does it seem like it's authentic? And how good is the testimony? So do we have the person who is testifying, can they say, yes, this is the phone number that I always get texts from, and I remember seeing this text, and no, it hasn't been altered. And so we're hearing a lot more of that and being perhaps not as hard on people to get things into evidence, as long as far as we can tell when they're proving it up, it does seem authentic. And then once you get it in, there may be other evidentiary objections to hearsay or relevance or anything the next step after authenticity. But it's definitely a challenge to the lawyers. So they are doing a great job of making sure that they are moving forward to try to have their hearings happen. On my end, for my civil and family law, any hearing that somebody wants to have by Zoom, I will let them. Sometimes I can give the option of written submission, but otherwise we are setting every single thing that was on the docket by Zoom. And so let me clarify that. When I say I will let them if they want to, right now we are saying is you have to have the hearing, and if you don't want it, you do procedurally just like you would any other case that's been set. You need to file a motion for continuance. I will hear that. And what's also been interesting for the lawyers, it's not just, I want to continue the hearing because it's just not as good when it's over Zoom. And I recently had a continuance hearing like that. And hey, I get it. I know it's not as good over Zoom. I know it's hard to make objections, and it's a lot tougher and to have a smooth case that you can present to the court, but that's the best option we have right now. So if the objection or the reason for the continuance is just because it's a Zoom hearing, that's going to get overruled, and we're going to be moving forward with the hearing. I have had some objections where it may be a situation like this. Hey, I can't have a full bench trial that goes all day long because I have 4 children and they are all here, and there is absolutely no way that I can have quiet the entire time. I haven't had anybody use that yet, but I'm kind of expecting that it may be coming. And that's when we just have to be flexible and try to figure out, all right, do we have part of the trial the first day and part of the trial another day, or how can we be flexible to make it work? And we are calling witnesses by Zoom. So what does that mean? And I've had some lawyers say, well, how do you subpoena someone? Well, you do it just like you would otherwise, but instead of telling them to come to the courthouse, it says you will appear by Zoom, and there is a link, and the person is to show up. Now, as far as what does that mean if they don't show up, can you hold them in contempt? We haven't gotten that far yet. I haven't had anybody not show up yet. And I think so far it's actually been easier, I think, to get witnesses to appear because they don't have to drive to the courthouse. We can go out of order if we need to, just like we could at the courthouse, but sometimes that's a little bit easier, or they can just work and do their email until they are called as a witness in the case. And so we've been able to do that. And of course, Zoom in general is just, it has its own challenges. And I thought it would be fun for Judge Novak and I to kind of give you some of our perspective on what we've seen. I'll just start with things like, we have a lot of self-represented litigants in family law cases. And so one person appeared in their car. I think Judge Novak had another situation. I'll let you talk about.
So obviously you get a lot of different characters coming into court, depending on what kind of cases you have, whether or not they're family or criminal. I will point out, I know some of the people that are watching, if y'all do have questions on YouTube, just go ahead and type them in. There's a way that you can chat there and ask questions. So if we're covering a topic that you need a specific question on, feel free to ask. But kind of piggybacking again on everything that Judge Edwards is saying, we do have some significant challenges. My first Zoom hearing, I had a party, one of the, I guess it was the respondent in the case. You could just see that they popped open their laptop while lying in bed there at 9 a.m. There's the covers, there's the headboard, and their wife sleeping right next to them, or I guess awake right next to them. It was a little bit of a challenge because I wasn't quite sure how to react and what to do in that situation. And we do have rules in place now to make sure that everybody, is dressed and doesn't show up in bed for their hearing. But that was the first one. So it's kind of one of those like, oh, great. What do I do now? Please don't get up. I'm not sure whether or not you're wearing anything, below the waist. So let's not have one of those, moments you hear about on the news. So that was, my first challenge. As Judge Edwards said, a lot of people do respond. They show up probably a little bit better than they did for court when we summoned them before. Now that they can do it from home or do it on their phone, the biggest challenge is getting them, logged in properly where their sound works and that their video works properly. That takes a good 10 to 15 minutes at the beginning of every hearing, just to make sure that everybody is working properly and everything is going smoothly.
I added one of my favorite memes right now.
Yeah, so there's different things that people can do in terms of the software, depending on what you're using. So we've talked about that. We've talked about backgrounds as well. I have my favorite backgrounds that I use. Kind of along the lines of that one, I can look up at the Brady Bunch, look around, or, appear with various friends and family in pictures and background. I try not to use these during court, but sometimes they're necessary because court can be very boring. It just depends on kind of your personality. I would, again, check with the court to make sure that they're going to be okay with the particular background before you actually start the hearing and proceedings as they were. We all kind of have the ones of our courtroom, and that's what most everybody is using. One of the things that we also talk about is just kind of being ready to be a lawyer for these hearings. It's difficult to have any kind of trial advocacy while we're having court. And so we've had lawyers that use signs, where they'll hold up a sign that says objection. There we go, Judge Edgeworth has it. Because if everybody's on mute, then you might not be able to raise an objection. Each court, again, is going to do things a little bit differently. So watching those courts again in advance will help you kind of prepare for it. And then the biggest thing that I would tell everybody is to practice. This is not going away. Zoom hearings are going to be here to stay in many respects. There are things that judges really like about it. We can do translation and audio feeds for people of different languages, which is really great. It works a lot better than what we do normally in the courtroom with translators. And if they're hard to find languages, we can literally now, call the country and have a translator in that particular country translate the language if we have to get to that point. So finding people is a little bit easier in terms of having that. And once they learn how the process works on Zoom, it really does work well. So certain things will remain. And I think those students who are in PC looking to come out and be lawyers here shortly, you're going to have to know how to be you in the courtroom while on a Zoom hearing. And whatever that entails is going to be kind of up to you as to how you work best. But it's also going to take cooperation with you learning how the court in your particular jurisdiction wants things done, or the courts. We've got 13 district judges in Collin County, and you've got 50 plus courts in Dallas County, 50 plus courts in Harris County. Those are all things that you're going to have to kind of manage as a lawyer as to in each court, what's the judge going to like? We talked about holding people in contempt. Many of you might have seen the contempt proceedings in Dallas, how that played out. Everybody was wearing masks. They were passing a cell phone around in that courtroom for the hearing. It's going to depend based on the technology and based on the judge's preferences in each particular jurisdiction. So keep that in mind when you're deciding, kind of how to proceed. And I know y'all are going to be doing a lot of practice with regards to, Zoom trials and mini trials and your big trial. Will probably incorporate all those things into it. I'm sure your professors are coming up with great ways to destroy your weekends and kind of torture you guys. That's just kind of what they do, but anticipate that going forward. So again, look around, see what everybody is doing, and you may need to make signs that say objection and have those kind of hearings so that you don't end up looking like a fool. And I will say this, you guys, again, are going to be better prepared than anybody else. So just know that going in. And the last thing I'll mention is something Judge Edgeworth was talking about in terms of submission dockets. So I didn't know what that was as a criminal lawyer. Basically, it's where, the judge decides everything based on motions that you file, and, everything gets done that way. And there are many courts that do things that way. And I am not a great writer when it comes to those motions. So I would tell you, make sure that they look good in terms of at least the proper format of the court and what the court wants. Sometimes what you say isn't going to be as important as all those things that the judges hate to see when it comes misformatted. I have found in my few months on the bench that I can tell pretty good lawyers from the bad lawyers very easily. And once I've read through their documents, I know pretty much who I'm going to listen to for the right type of information. And while they may surprise me in court, it's likely that the ones that come prepared, the ones that come with the proper paperwork, the ones that come with the proper paperwork that looks like it should, are going to be the ones that win out in the end. And that's just, I guess a practice tip for you guys in terms of how that goes. It does matter, how you present your information, especially when we have to read it, we have to go through it, and it doesn't make sense, or it's not formatted properly. It drives judges insane, and you lose credibility right off the bat. So practice. Get with somebody who is a much better writer than you. I married the person sitting next to me in PC, so that was my way of winning that battle. That may not work for everybody there, but try to find somebody who's going to be a good friend And we'll point out that the people you know in PC are going to be the people that help you find jobs, that help you write, that help you do your job as a lawyer in a much better way as you progress in your career. And I would not be here without the people that sat in that long row in PC and got asked all the hard questions. So by the time it got to me, Professor Powell would just say, "Do you agree with that?" And I'd say, "Yep." And that was my check mark for the day of talking in PC. So things work out. They hopefully will work out for you as well.
Okay. I was going to talk about some more practical how-tos and what this really looks like when you're trying to present your case in the courtroom. Step one is to make sure that if your court has its own Zoom procedures. I think every one of us do in Collin, and on the Collin County District Court's website, we have links to our policies, and they're pretty similar. But for example, how do you submit exhibits? So some judges have a Dropbox that they are asking all of the parties, usually it's by noon the day before the hearing, to submit their exhibits to the Dropbox. And what we always tell them as well, whatever exhibits you can agree to before the hearing, it will make it go much smoother. That's true for trial too. But there are some exhibits maybe you don't want the other side to see yet, or maybe that's for impeachment, and we get that. So if that's the type of exhibit that you're talking about, that may be the one that you're trying to admit at the hearing. You definitely need to practice sharing your screen if you have not already. At the bottom of Zoom, it's green with a little arrow and it says share screen. And part of being prepared for your hearing is to make sure that your exhibits are up and ready so that when you hit share, you can click on whatever exhibit that you are wanting to share. And then that is what your witnesses will be looking at, and the other lawyer and the judge as well. As far as how do you object and do your hearing, when Judge Novak was talking about the actual piece of paper that says objection, what I realized, this was last week, what was happening when you're trying to object, you're talking over each other. And what I found in Zoom hearings is I do a lot by listening. I take a lot of notes. I'm usually not looking up, and that's the wrong thing to do in a Zoom hearing, because I need to be paying attention to somebody trying to make an objection. Because once you make it, if you're talking over the other person, which you have to do usually, it goes out and you can't hear it. And then inevitably what happens is you have the lawyer trying to make the objection. The witness has already answered the question and told me the hearsay. And then the poor lawyer that was trying to object says, hearsay. And yes, it was. And now we've all heard it. So what we found out was a great way to try to do that. It's slower and it's a little bit more clunky. But if you have the sign that says objection, and if the judge is paying attention, and I'm trying to do a better job of that as well, looking at the screen, the question gets asked, I see the objection, I say, Lawyer B has an objection. Lawyer B, what is your objection? Hearsay, Your Honor. Lawyer A, what's your response? Present sense impression. All right, overruled. And then the witness can respond. And by then they've forgotten what the question was to begin with. And so you start that process all over. But that makes a clearer record. And keep in mind too that the record, so I have as one of my Brady Bunch boxes, it's my court reporter, and she is typing what is being said. And that is still the official record. And so you are still going to try to do the best you can to speak clearly, speak slowly, even though you're looking at a computer screen and you can say, oh, at the top right, it's green. If you're trying to talk about an exhibit, you still want to do all of those things that Baylor teaches you to do, which is really talk through what you want to be able to read on a transcript. And so those skills will still come in handy. And I will say too, that of course, the best thing about being a Baylor lawyer is you're always going to be the most prepared in the room. And preparation is even so much more important now for these kind of hearings, because you've just got to be ready with your exhibits. You've got to be paying attention to what's happening on the screen while you're also trying to take notes as a lawyer. So it's tough that you can do it. And then I'll share one of my other favorite memes. Yes, unfortunately, all of our Zoom meetings pretty much right now are with video. So we are all still having to get up and, well, not Tom, but I have to do my hair and put on makeup. I do think most people are wearing shorts. So at least you just have to be pretty here. So that works nicely. I did want to talk about some ethical implications of Zoom and YouTube because it's really brought up an interesting conversation with the judges and the Supreme Court on doing YouTube. And why are we doing that? Well, because we have a constitution in Texas that requires all courts to be open. Well, what does that mean when I am online and somebody can't just walk into my courtroom? Well, the best solution that the Texas Supreme Court decided on was YouTube, which is why most courts have set up their YouTube channel and we live stream our hearings. And we do that to try to comply with open courts. What's weird about that is that's not really what it's like in the courthouse because if I'm in the courtroom, the litigants know if their neighbor just walked in and is watching the proceeding. If I'm here in Texas, I can't walk into a court proceeding in New York. Or if I'm in another country, I can't walk into a proceeding that's in Texas. And as lawyers, you may be showing things that include bank account numbers or trade secret information or confidential sensitive information of the person in the courtroom. The interesting aspect to that is it was always being presented in an open court. So for example, if I have trade secret litigation, I'm talking about that in the courtroom prior to Zoom hearings. So what do I do now? And the Texas Supreme Court has come up with basically you as a lawyer, you just tell the judge, for example, if it's trade secrets, this is trade secrets. This is a part of the proceeding that we do not think should be live streamed to YouTube. The court will ask the questions. Basically, we do a hearing about it. And if the court agrees, then I can turn off YouTube for a certain amount of time if it's that kind of information. I think it's been good for the lawyers to try to keep in mind that this is happening. And as they're forming their questions, do know that other people may be watching. What that's also meant for lawyers, and this came up in a hearing recently, the lawyer could tell, it was a family law case, the lawyer could tell that there was another person in the room that the witness was talking to. And so the lawyer asked the question of the witness, who's in the room with you? And I had invoked the rule. So when we realized who was in the room, we asked that person to leave. And we reminded all of the parties that you can't have anybody in the room with you. The lawyer then asked, what did you talk about? What did he say? And it wasn't a big deal. But that raises issues like, how do you invoke the rule? Well, I have to admonish anybody that's a witness. Don't watch this on YouTube. Don't text to any of the lawyers that you're talking to right now. You can't text to any of the parties. And I have to hope that they do that. Well, I have to hope that too when I'm in the courthouse. They could be outside texting. And if you're a lawyer and you're really worried that that's happening, you handle it just like you would in a regular proceeding. When that witness comes in, you ask them the question, did you talk to anybody about this case while you were outside? Did you text anyone? Have you received any texts during the course of the proceedings? Another nice feature that we have in Zoom also is called breakout rooms. So that allows the judges to put in a room by themselves, the lawyer and their client. And I did this in a criminal case recently, because if they're remote, the lawyer may want a chance right then to talk to their client. And that works. I can't hear what's going on in the breakout room. It's not recorded. I don't know anything about it. And then when the private conversation has happened, we let them back in. So lots of interesting implications that have happened from Zoom. the right to confront your accuser. The Supreme Court has weighed in on that and said you are confronting them. They're on YouTube. You can see them, or on Zoom. You can see them. But a lot of areas that we've never had to deal with before. I don't know if there's anything you've thought of, Judge Novak, if I've been talking that's come up.
Right. So, I mean, a lot of those things that you mentioned, and they're going to be specific to each area of the law that kind of come up. And as the lawyers kind of have to go through it in their own cases, you're going to be responsible for kind of figuring out what those issues may be. So when it comes to doing exhibits, go ahead and redact the personal information that's on there so that it's already redacted when you get in there. Nobody's going to object to that. Nobody's going to have a problem with that. And if there's something that somebody does object to and say, well, we don't know what's underneath there, you can obviously share that the original copy with the other side or the other attorney in the case or the court itself. And it's never really going to be an issue. You know, if it says SSN and then it's a black mark after that, we're probably going to understand what that means and it's not going to be an issue. So you, again, as the lawyer on the case, are going to have to take some initiative to kind of go through those traps. And again, that's your job as a lawyer to kind of figure out what that may be, depending on whatever type of hearing you're having, whether it's in person or on Zoom. You know, those are going to be things that you have to practice with, and you have to kind of work through the case to figure out the specific issues. So in family law cases, we a lot of times have to interview the child outside the presence of the families to determine, you know, who the child wants to go live with. Well, how do we do that if the child is at home surrounded by their family and parents, and they hand them the phone and say, talk to the judge to figure out where you want to live? That's a little bit of pressure, especially if the kid doesn't want to live with that particular parent. So we ask them to do things like get in a separate room, you know, flip the phone around so that we can see that there's nobody else in the room. You know, we tell them to talk softly. Those are all things we've kind of had to come up with on the fly. You know, criminal cases, again, you know, I've had not any on Zoom, fortunately yet, but we have cases that deal with child pornography. We have cases that deal with rape and children and individuals that all deal with those kinds of sensitive subjects that we don't want to handle in an open forum for everybody on YouTube to see. So those, again, that varies depending on which type of cases that we're doing. And again, civil cases in terms of the types of exhibits that are getting put in, those may have certain information that you don't want the other side to have. And then also when it comes to the presentation of the exhibits, you know, some courts are requiring that they be shared prior to. If you're trying to impeach somebody, you may not want to share that, or you may not have that information, you know, available when you're originally sharing the information with the other side, and you want to impeach them with something that pops in your head. So you're going to have to understand kind of how that works in terms of handling the exhibits as they come in through screen sharing or emailing them to the court. And, you know, I can look at my computer screens while we're having the Zoom hearing. And so if you need to email something to the court or to the court reporter to do that, those are all things that can occur kind of instantaneously while you're sitting there at your computer as well. Generally, I think for most courts, the court reporters are the ones who handle those kind of issues in each particular court. So emailing them is going to be the best way to go about doing those particular issues. So I will kind of give it back to Judge Edgeworth here in just a second. I did want to answer this one question that we have. Christian apparently asked a good question in regards to what type of stuff we're using, whether it's just Zoom or other programs. I will tell you that we do have other programs that certain counties use. For the most part, I think you'll find that in Texas, courts across the state are using Zoom because the Office of Court Administration got licenses for all of the judges in Texas to use it. It works well. Most of the information that we have is based on us kind of using that and developing the processes and procedures. You heard Judge Edgeworth mention the breakout rooms, how to share a screen. Those are all things that most judges are familiar with. But just down the road in Dallas County, they're using Microsoft Teams just because they wanted, their IT department wanted to use that particular program. Over in my wife's federal court, they're using Cisco. I think it's Jabber or you know, WebEx, one of those that they're using. And so if you're going to be a practitioner in certain counties or urban counties where you might have to go to a couple or different, you have to get knowledgeable in each and every single one of the particular programs that they use. So just keep that in mind. It does vary from place to place and the type of courts. I think most of the federal courts are using Cisco systems. Most of the state courts are using Zoom, with some using Microsoft Teams and WebEx in other places. So download those, play around with them, put them on your phone, do what you need to do just to make sure that you know how to use them.
I raised my hand because Liz had a question that was a real good one. Who marks the exhibits for the official record? And that's why we've been asking whatever exhibits that you're going to admit for the hearing, they should be pre-marked. They need to be sent to the court reporter and opposing counsel before the hearing. And that is the exhibit that is admitted unless something comes up otherwise at the hearing. So for example, I had a hearing last week where there was a medical record, there was an objection to hearsay, there was a response that got part of it in, but it's not going to be the entire medical record. So what we had to do was I had the party that was offering the exhibit, and based on what we had all agreed on was going to be admitted, they had to resubmit after the hearing another exhibit with the redactions and had to show the other side. So the other side knew, yes, this is the exhibit that was coming in. And then that was the official exhibit that went into the record. So sometimes you just have to be creative. And like Judge Novak was saying, it may be that you're emailing an exhibit during the hearing. And the main thing is you just want to make sure that whatever is admitted is what everybody's looking at, and that nothing has been altered on the actual exhibit that's admitted at the hearing.
And Judge, I'll add this. Probably y'all have already heard, or at least through being at Baylor for last couple of years, you know that the people who run the courtroom are not the judges. It is the staff, it is the court reporter, it is the bailiff. Those are the people who run the courtroom, and so all those rules will go through them. My court reporter, for instance, likes to have all of the exhibits that she takes at the end of the trial that have been admitted in chronological order. That's not the way that all of them do that. Sometimes they'll take them, plaintiffs 1 through 16, and half of them haven't gotten admitted. They're noted what they are for purposes of the record, but they haven't been admitted. And you can submit all of them kind of together for purposes of the record and objections, but the only ones that are considered by the court may be 8 through 16 versus 1 through 8, which got denied admission. So it just really does depend on each individual court and each individual court reporter, bailiff, or court coordinator as to how that works. And again, you have to take the time in advance to do that, because if you try to do it during the hearing, it just slows things down. It pisses the judges off because we're wasting too much time trying to get you to email your exhibits versus sending that stuff to us in advance and having it ready to go. And the biggest thing for Zoom and all these other systems that you'll realize is it takes so much longer just to get everybody going and everybody started, that your 30-minute hearing becomes an hour-and-a-half long hearing because of the process involved and making sure that everybody's clicking on the right thing. And some people are getting muted. And it is something to keep in mind. If the judge tells you we're going to take 30 minutes and you're an hour-and-a-half into it, you're doing something wrong and somebody's not going to be happy. So just as a practice tip, keep that in mind.
Oh, and we still time people. So in Collin County, our temporary orders hearings usually are 20 minutes aside. Now, I've been giving more than that because it's so hard. Even the best prepared lawyer, it's really tough when you're in the courtroom to get it done in 20 minutes. So if you know you're going to need more time, ask the judge, and a lot of times they'll give it to you. What I wanted to, and we might have a few more questions at the end, but what we wanted to leave you with were words of hope. What does this mean for you as a law student? If you were at that point in time where you were trying to get a clerkship, I mean, we were supposed to have 2 phases of clerkships this summer, and I think we are not doing the first one. How do I get a job? What does this mean for me when I can't be out in person? Because that's how I meet people and sell my, you know, let people know how great I am and why they should hire me. Best advice we can give you is just keep up the network with you that you have with first your friends in school. I think as Judge Novak mentioned, he married his person. This was my mock trial team. One of the women to my left is the godmother of my child. And one more, Abby Francis, spoke at my investiture. We were roommates after law school and mock trial partners. And I'm still friends with everybody in this picture, even Professor Powell. Look how dark his beard was. Yeah, that's 1999, everybody. But these are your friends that right now you're just eating pizza together and trying to make it through law school. But soon, sooner than you realize, they're going to be the owners of law firms and the partner at the firm. And even now, reach out to anybody that is, if it's at a firm you want to work at, look at where they went to law school. I often would get letters from students that were in law school who maybe they just wanted to do a quick coffee. Well, we can do a Zoom coffee if you're trying to meet with people to ask them about their law firms and just to try to get to know them. So you do need to be a little bit more creative, but don't give up. Firms are still hiring. They still have work. It just looks different.
So when I came out, I graduated in 2005. So that was right at the last, or the beginning, I should say, of the last depression or whatever you want to call it. And we had a number of people in my class that had a hard time finding jobs. I anticipate that that's kind of going to be an issue for everybody going forward here as well. Best as we can tell, law firms are cutting back on a lot of things until we kind of get an idea as to where that may be. So hopefully in a year, we'll be back to somewhat of a normal posture. And those of you who are going to be graduating a year from now, are in a good position in that hopefully the economy will be going back to where it was. So there's going to be some fear, there's going to be some issues, but I will tell you that everybody who made it out of my class is doing really well. I haven't really heard of many people who aren't. That's a positive thing I think for everybody to think about, is that we have a lot of success specifically from our class. And we did, I think we did really well with the people we had. So just stay with it. And as Judge Edwards said, take the time, email, pick up the phone and call. It's not that hard. If you're looking for an internship, if you're looking for a clerkship, if you're looking for some advice, most of us are going to be ready and happy to answer that call. And it may not be with us, but maybe we can put you in touch with some people who do know about that stuff. Take advantage of the opportunities. I know my wife helps out with the clerkship symposium, I guess that goes on at Baylor for some of the federal clerkships. We do have internships. We can slot people in sometimes. So if you have a couple weeks and you want to come and watch trials, or have me give you some kind of busy work to show that you've done some work, I'm happy to work with that as well. It just really depends on kind of what it is you're going to be doing and what you think you're going to be doing. And for those of you who don't know exactly what you're going to be doing at this point in time, that's normal too. Don't get freaked out by some of the people who already know where they're going. I did not specifically know what I was going to do. I knew I wanted to go be a prosecutor, but they didn't hire people until you passed the bar. So, I was the smart one. I went to Vegas to get my bar results, which I will recommend to everybody when it opens back up, to go get your bar results in Vegas and have a good time with your friends. Because then the next day you get a call from the various places that may want to hire you. It is different for everybody. So just, keep that in mind and keep working at what you're doing and where you think you might be in the next couple years or 5-10 years down the road.
And I can definitely say, I am thankful every day I'm in the courthouse for my Baylor law education. And that may sound cheesy, but I mean it. I know when it's a Baylor lawyer, there is a difference, and our professors are still so involved. You really do get the top-notch education. And oh my gosh, they're doing Top Gun by Zoom. How real is that? So we're excited for that. The Judge Novaks, plural, are going to go judge, and I think some others are going to be judging remotely. So we're excited. All right, should I unmute you? There we go.
This is great. Thank you. Yeah, we're just trying to figure it out. And while it's a lot to think about, I'm with you. I don't think Zoom hearings are going away. I don't think Zoom depositions are going away. And it may be a very marketable skill to come out and say, I've tried 3 jury trials and 2 bench trials in law school, and I'm very comfortable with the courtroom technology. Obviously, with big trials, we're hoping that they'll wire in TrialPad and some of the courtroom technology there. One question I had for y'all, how are people handling demonstratives if they are?
So we had a trial where we did have some demonstrative aids, and you know, they kind of work the same way as you would for any other kind of evidentiary issue, right? You try to admit them depending on the proper time and the place. Now, as for whether or not they get put in with the record, that's a whole nother issue in terms of those issues, but it works the same way. So you're going to have to go through the process of having the judge either see it before or have the court reporter see it prior to you know, its admission as a demonstrative. So I, for instance, do not see the exhibits. My court reporter and my court coordinator see them, and then they send me an email, and I don't open them until the attorney wants me to take a look at it and is using it in court. Honestly, they may give me 20 things. They may often use just one. So I'm not going to go through that and, you know, kind of muddy up the waters by reading a lot of things that I don't need to. And if you just saw the Supreme Court case that came out, I guess it was last week, that basically said that the courts can't come up with arguments that the parties didn't raise. They slapped the Ninth Circuit down in a unanimous opinion from the Supreme Court saying, hey, y'all went out of your way to go get this other argument just because you wanted to. I'm not going to do that. One, I don't want to. I'm not going to waste my time doing it. Two, I don't care to come up with your work and your job for you. And I let the parties kind of play that out. So demonstrative aids, as they play up in court, we're happy to see them, but just use them in the same way you would use any other kind of evidentiary issue.
I haven't had anybody try it, but I would agree. I think all of the judges, I know, I can speak for Judge Novak and myself, we're giving everybody a lot of grace. We need grace. I mean, this is different for everyone, and in some respects, we're kind of getting through it together. But I know our lawyers are working really hard to try to make sure that they can keep their cases going and keep their clients moving forward.
Part of it is you do have to kind of fall back on the honesty and integrity part of being a lawyer and being a judge. So without sounding too corny, I'm really not going to consider the stuff I'm not supposed to consider. I'm only going to consider the stuff that you put in front of me. I hear it, but half the time it doesn't really matter. It goes right over my head. I mean, after you've sat through some family law trials and criminal law cases, you hear pretty much everything. And so you have to be able to parse out those arguments. So I would also encourage the students not to get wrapped up with some things coming in or some objection getting overruled and the judge hearing those factors or hearing those things that you don't really want them to hear, because a lot of times it doesn't matter. The judge is going to hear it, but it's not going to have the effect you think it does. In fact, it usually has the opposite effect. And so we're looking more for credibility of the witnesses. Why we like Zoom is we can watch people close up, see their facial expressions. The witnesses and the parties are all rolling their eyes in the Zoom hearings. We see all that. They're commenting to somebody in the room next to them. We can see that. You know, they're furiously typing away at their keyboard because they're angry. Those are things that we see, and when they're talking, that plays into their credibility and those issues. So I would tell you right now, everything kind of comes in because it's up there and we see it. But We don't really consider it because that's not our job. And I think for the most part, judges are pretty good about doing that. I haven't seen anybody taking into account things that they shouldn't. But we do watch and we do see everybody on there and their expressions and attitudes. And those play, I think, a much bigger role in terms of your advocacy in your case than they would have before if we were in person.
Thank you both so much for your time. This has been fascinating to hear what it's like on the front lines. And we'll see you both for Top Gun.
All right. Thank you.
Bye, everybody.
To end the meeting.
Thanks.
So we don't have the awkward moment of staring at each other. Y'all have a great afternoon. Bye.
Thanks. Bye.